Good morning, everyone. My name is Bill Gorman, and I'm a partner in the Corporate Securities Group here at Goodmans. And it's my pleasure to welcome you to Goodmans today for our program, Navigating the Minefield of Disclosure Obligations. We've got a great turnout today. We're very excited about that, both in person and there's a fair number of people on the web as well. So we're delighted that you could all join us this morning. Before we get started, a couple of administrative items to attend to. For any lawyers in the room, this morning's session will be eligible towards the substantive hours of the Law Society's CPD requirement. And based on the number of lawyers that I've seen here, I have a feeling a fair number of us got the notice from the Law Society that we need more CPD hours for this year. But we're happy you're here, and it's going to be great. Everyone will be receiving a proof of attendance email after the session. Please retain a copy of that email for your audit, for audit purposes. The email will also walk through how to report the session on the Law Society portal. And if you have not done so already, make sure you sign in at the front desk. That's how we get your information for the email. And finally, as we go through today, we're happy to take questions from the floor. We think that'll liven up the discussion and hopefully address issues as they come up. So if you have a question, please raise your hand, and there's a couple of people that will be roaming the floor to provide you with a microphone for the question. So now let's get started. The idea for this morning's program arose as we watched the events unfolding at Home Capital Group over the spring of this year, and which ultimately culminated in a major investment by Warren Buffett's Berkshire Hathaway to stabilize the company. Home Capital's issues arose from a failure to make disclosure of a material change back in 2015 when it discovered that a number of its mortgage applications had been falsified, and as a result, it dismissed a number of mortgage brokers. What we found interesting as a bit of a securities law nerd is the issue that arose in Home Capital goes to a fundamental issue in our securities laws, and that is making disclosure, public disclosure of material changes. And Home Capital illustrates to all of us the importance of getting that decision right and the implications that can come of it if you don't get it right. The other thing that we found interesting about Home Capital is it actually was initiated, I think, came about as a result of a whistleblower complaint, first to the board of Home Capital and then second to the OSC. And I think that's what ultimately led to the situation it got itself into. Determining when a material change occurs is among the most difficult decisions public companies face and which we deal with every day as securities counsel. So the purpose of this morning's session is to explore what a material change is and to discuss the possible implications under our securities laws from a regulatory perspective and as well from a litigation perspective. To explore this topic, we're very fortunate to have Jennifer Lynch of the Ontario Securities Commission here today to speak to these issues. Jennifer, we've been able to get, I think, very high-level permission from the OSC to unshackle her, and we're told we're going to hear all the secrets of the OSC today. Jennifer may correct me on that, but
yeah.
So for their biographies, Jennifer is Senior Litigation Counsel in the Enforcement Branch of the OSC. Her practice focuses on allegations of securities fraud, unregistered trading, illegal distribution of securities, and insider trading and tipping. Jennifer has conducted several lengthy hearings before the Commission and was the OSC's primary litigation counsel in the Home Capital matter. Jennifer was also co-counsel on the Finkelstein insider trading case. And then on my far left, David Conklin is a commercial litigation partner at Goodmans. David's practice focuses on corporate governance and business valuation, and he has extensive experience appearing before all levels of courts in Ontario litigating commercial disputes. David has acted on some of the leading securities class action cases in Canada, including Look Communications, Western Coal, Atlantic Power Corporation, and Manulife Financial. And these decisions are all, I think, some of the leading cases in Canada that have shaped our securities class action regime, and his involvement has had a significant influence on how those cases play out. Then on my immediate left is Brad Ross. Brad's a partner in our corporate securities group and heads one of our business law groups. Brad has a broad transactional-based practice involving all aspects of corporate and securities law, with particular emphasis on corporate finance, mergers and acquisitions, and private equity transactions. Brad also regularly assists companies with their corporate governance and continuous disclosure obligations. Brad's the guy you call when you say, do I need to disclose this? And then sometimes Brad calls David and says, if we don't disclose this, are we going to get into trouble?
And then Jennifer gets interested.
That's the question we're going to find out today. So let's get going. My first question today is for Brad. Brad, could you spend a few minutes discussing what a material change is under our securities laws and the key factors that a company should consider in evaluating whether a material change has occurred?
Sure. Again, I'm happy to be here and give the corporate securities perspective on some of these issues. I think it is so valuable for those of us on the panel in the room to get Jennifer's perspective as OSC Enforcement Counsel. As mentioned, it's fantastic to have her here today, but as I told her earlier, I will be just as happy if we never cross paths again after this morning's session.
And I take no offense to that.
Yes, professionally, of course. Yeah. So going into the definition of material change is defined under our securities laws as a change in the business, operations, or capital of a company, of an issuer that is reasonably expected to have a significant effect on the price or the value of a security. So in theory, that's a straightforward, easy test, but those of us in the room who deal with these issues know that in practice it's anything but, and it's actually a really difficult concept to discuss in a forum like this. But we will do our best here. So in my experience, when companies are looking at disclosure questions, they often start with the first part of the test, right? The materiality aspect of the test, and whether, which we often refer to as the market impact test. And questions of materiality or market impact are among sort of our least favorite questions to receive. We lawyers like bright line tests, and this is just not a bright line issue. There's an abundance of guidance out there on the issue. The regulators have published a national policy on giving examples of what may constitute material information. There's a growing abundance of case law on the issue that David has been involved in. The stock exchanges have published some guidance, but again, it's of limited use. It only addresses a small fraction of the potential issues that public companies face day to day. And the best guidance, I think, that comes from the national policy is that it's not a bright line test, and every determination is highly contextual. You have to look at every circumstance in light of the nature of the company itself, its business, the volatility of the company's securities, and the prevailing market conditions to try to make your determination. It's important to note, I actually had this discussion with a client just last week, that it's not a quantitative test, right? I think many management teams look at these decisions and say, what is going to be the financial impact in the financial statements or otherwise, and it's not purely quantitative. There's a strong qualitative aspect to the test, and my gut is that sort of that played a key role in how the OSC certainly looked at home capital and some other regulatory decisions. So once a company has determined that a change may be material, it has to consider the second part of the test as to whether the information constitutes a change in the business operations or capital. And again, our securities laws distinguish material changes from material facts, and they provide that only the former needs to be disclosed immediately in the form of a press release and a material change report. Material facts or information, there may be other forms for that, but it's the material changes that trigger the immediate disclosure under our securities law regime. And we often struggle with this determination in the context of external developments. So again, the securities regulators have provided that companies are not generally required to discuss or interpret the impact of external events on their business, external political, economic, social developments, unless those developments directly impact the business in a material manner and impact the company in a manner that's different or uncharacteristic from how others in the same business or industry are affected. And there are court decisions, coming out on both sides of that. There's the very famous Danier Leather decision, in which the Supreme Court of Canada determined that unseasonably warm weather that had a softening on a company's intra-quarter results, Daniel Leather's intra-quarter results, did not constitute a material change in the business operations or capital of Daniel Leather. On the flip side, there's a case involving Coventry, in which a court determined that a decision by a rating agency, DBRS, to stop rating certain types of asset-backed commercial paper did in fact constitute a material change for Coventry, because a material component of Coventry's business involved the sale of this commercial paper, and that part of the business was materially affected by this. So again, highly contextual depending on the circumstances. The final point I think I want to make on materiality, and actually all disclosure tests for that matter, is that it's an objective test. And the subjective considerations that we often consider, especially as lawyers in other corporate contexts, don't apply necessarily to decisions of disclosure. And I think this really came to light for a lot of people in the home capital announcement this past summer. When the settlement agreement was announced, I received a number of calls from directors and officers of public companies who were taken aback by this news. And the press, I think, really picked up on aspects of the settlement agreement, which we acknowledge are negotiated documents, but the press highlighted sort of all the good things that the board had done through the process, right? When the issue first arose, they conducted an internal investigation. They hired a third-party audit firm to come in. They struck an independent committee. They reported the violations to CMHC, OSFI, and an external auditor. The settlement materials make note to the board, keeping the management keeping the board apprised. They consulted with advisors on a regular basis. So to many people, management teams and directors, they said these were all good facts. But at the end of the day, I have to say that they are good facts, but it's not relevant. At the end of the day, this is an issue of disclosure, and when it comes to matters of disclosure, companies and the directors and officers can't necessarily insulate themselves from exposure through following a proper process or exercising business judgment.
And maybe just one thing to touch on, and one of the difficult things I think companies face when they're trying to decide whether to disclose or not, you're making a decision as to what you think the market reaction will be to a certain event or news. In home capital, they fired about 30 brokers out of 4,000. They terminated 3 brokerage companies out of a high number that they used. And they expected the impact of the loss of the brokers to be about 10% of their mortgage originations, or at least for the previous fiscal year, this group of brokers accounted for about 10% of their mortgage originations. And so they're looking at it saying, well, it's bordering material. It's 10% of our new originations, but you can see how it would be a tough decision just on the financial impact. What I think, ultimately, that when they disclosed the information, the stock dropped 20% the next day. And so, the company was looking at it not knowing how the market would react. But when you look at it now, you say, well, of course the stock dropped 20%. Of course it was material. And so this is the difficulty, I think, this really kind of hits on the issue of how difficult this issue can be for companies. Unfortunately, we get the emails. Brad and I, our practices are very similar. Do we have to disclose? This is what happened. And they email us and say, do we have to disclose? And unfortunately, we're usually in a position where we have to send back an annoying lawyer email and say, well, this is the test for a material change. You're the one that's best positioned to evaluate. And in home capital, maybe the factor that resulted in the change, it wasn't the impact on the business, because at the end of the day, the business was pretty much okay. It was I think the concern around that industry and alternative mortgage lenders, and there was a housing, everyone talking about a housing bubble, and the media was promoting that, and so the market was really, I think, impacted by the sort of broader circumstances.
Just on that, Bill, I mean, I'm not always so sure that the market impact test is as difficult to think through as you and Brad have suggested. I think business people, for the most part, have a good sense of whether they think that the news that they might release is adverse and will have an impact on the perception of the business and could affect share price. The tougher question is understanding, I think, how do you characterize the event? Is it a change in the business? And the cases that Brad focused on, and these cases that deal with material change, really focus on how do you characterize the business itself, or in home capital, how do you characterize the operations? And if in Coventry you say the business is selling ABCP paper and you can't sell it anymore, then somebody can look at it and say the business has changed. In Danye, if you say sales are down, but you continue to be in the leather good business, there's been no change in the business. And so that's where the lawyers can get, and business people can struggle with evaluating, will somebody look at this and say there is a change or not? And if you know, just to pick up on your last piece on home capital, one of the things about thinking about disclosure is we're now looking at, you're looking at home capital retrospectively. If you look at it in real time, the information a board and management team are dealing with in home capital changes. So their concern in an initial disclosure, many times with people confronting a potential material change intra-quarter disclosure, is they don't know all of the facts. And so if you think about home capital, if the first announcement is we've let go of a group of people who are brokers because of their perceived misconduct, what's the issue for the market? The market isn't just you let go of brokers and what the impact of that is on new origination. It's, is there a qualitative problem with the business that they've written and that you've assumed a risk for? And that takes more than 48 hours to solve in terms of thinking about that. So a board could properly struggle with trying to evaluate, if we make a disclosure today, will the market read that disclosure and see it as being more adverse than it is because we haven't completed an investigation? Or the tough one for you and Brad is, can we defer making disclosure while we investigate? And I think that really is important to keep in mind, is that the facts that people have change as well as you go through this. And so the disclosure will change.
And if I can just add to that, I think Dave is exactly right that it has to be a dynamic process. So, I mean, Bill, you were referring to the fact that that in home capital they discovered the fraud and they fired numbers. Again, that was a quantitative assessment, but there was more than that. They took a look at their business and found that there was a problem, and so it wasn't just the firing of the brokers. It was they had to remediate, and they took a number of steps to do that. And so, what if you read the decision that came from the settlement, one of the things that the panel said is that you know, it is dynamic. As you go on and learn more things, you have to keep considering whether or not it constitutes a material change or material fact. And what they said is a delay by management in the release of information in the hope that it can manage itself out of a whole is not management's prerogative. And I think that sends a strong message that it's not just about the numbers, it also has to be qualitative and has to be ongoing. And what ended up there is the commission found that at a certain point, they knew enough that they had to disclose. So they were allowed to investigate, but at a certain point, it felt that it was material change that had to be disclosed to investors.
Yeah. Well, this I think our discussion up here is highlighting kind of the difficulties that we all, you know, working through these issues and companies face in dealing with them. David, did you have anything to add in terms of just thinking about what some of the more difficult disclosure decisions that you see boards and management facing?
Except when you call. I see it after the fact. But I think that, you know, as a message to people who are in the position of making the decisions, an important issue is that when you spot the problem, that is that there is an event that has occurred or information that comes to a board or management team, and you're considering what the disclosure obligation is, you need to be able to actually work through the analysis of whether you believe as a team there is likely to be a significant market impact if you made disclosure of that fact. And if you conclude that you don't believe it would, I think you want to have documented and have a clear sense of why it is that you think the market impact test wouldn't be a concern. If you conclude that you think it would have an impact, and let's be fair, we're not concerned with positive news, right? Positive news every issuer wants to release as soon as they possibly can. Mm-hmm. We're talking about negative news which is the kind of thing that everybody stays awake up at night about, wakes up early, and they stress about, do we have to disclose this? And management will have an immediate reaction, which is, this isn't as bad as people think. And their initial impression is not to want to make disclosure. So you satisfy the first part of the test, and then the second, I think, very important to be able to ask yourself, what is the justification, if you're not going to make disclosure, for being able to explain why this isn't a change in the business, the operations, or the capital? And you have to look at capital business. You got to look at each one separately, and then have a clear rationale to justify the conclusion. And if you have doubt about it, and if you think there's a problem and you choose not to disclose, you can know that if it has to be disclosed at a later date, if you have to make disclosure of that news eventually, there are two sets of people who are going to, at least two sets of people who review it, but I can tell you there are more. Here's all the people who review the subsequent or later disclosure. You get journalists, shareholders, analysts, the OSC, and your friends in this room, the plaintiff securities class action lawyer. And what they ask is, did the company know these facts earlier than they made disclosure? And then you study, did the company make statements in the period of time you think they had the facts that are inconsistent with this information? And that's the beginning of the problem for people. And the best answer to it is to go back to the beginning, and whatever the decision is that you make, not only have it documented as to what the decision is, but as a team have a clear rationale for why that conclusion was reached.
So I thought I'd turn the discussion a bit now. So we've explored material change, some of the issues that have to be considered in making that decision. Now I think what people are probably interested in is, how does the OSC catch people when they don't make disclosure? Jennifer, does the OSC have any kind of system in place or any process to monitor public disclosure, look for negative announcements, watch for stock price drops, those kinds of things? And then kind of secondarily, what is the decision-making process for starting an investigation into a matter?
Sure. So obviously, as a regulator, we have a different mandate than the plaintiff class action lawyers. Our mandate is to protect investors and ensure that there's confidence in the markets. So how do things come to our attention? It's actually a number of different ways. So a company itself may raise an issue and come and speak to us, and as we've already spoken about in Home Capital, that's exactly what happened. The board came in with the whistleblower complaint, and that led to discussions from there. So that's one way a company can come and speak to us. Another way it may come to our attention is part of our corporate finance ongoing disclosure review. They may do either their full review or an issue-oriented review, and an issue may arise. And if so, can be dealt with it by a number of ways. It can be corporate finance will send a letter, I'm sure many of you know, to the issuer and deal with it that way. Or it may get referred to us. So if it gets referred to enforcement, we will do an initial assessment. That initial assessment can either be done by corporate finance or can be done by us. And if we take a look at an issue, then we can launch a full-blown investigation. So I'll get to that in a second. Another way that disclosure matters come to our attention are through the contact center. So we often receive complaints or questions from stakeholders, so from investors or an employee or some other stakeholder in the company. As many of you know, we also have the Office of the Whistleblower now. That was just started last July 2016. So we may get a tip through the Office of the Whistleblower. And then finally, another way that it comes to our attention is we do have ongoing market surveillance that we do. So we monitor public disclosure and market surveillance looking at what share prices are doing. And that includes reviewing news releases and media articles as well. Then do you want me to go second half? So what happens if,
Sure.
so how do we decide on an investigation? As I said, it could either be corporate finance, could be enforcement. We take a look at an issue, so say we get something from an investor through the contact center, we will do a preliminary assessment and recommend that it should go to an investigation. What happens under securities law, we have to get an order in order to investigate, and that's an order of the commission under Section 11 of the Act, and they appoint people to investigate. It's a low threshold, so it's we investigate if it's expedient to examine whether or not there's been a breach of Ontario securities law. And then once we have that order, what that allows us to do is use our powers under Section 13 of the Act to compel information, either in the way of documents or have people in for interviews.
And is that order public or is it private,
No.
confidential?
Yeah, it is confidential, the Section 11 order. And then pursuant to Section 13, we issue a summons, so it may be issued to the CEO of a corporation. Counsel can ask for a copy of the Section 11 order, but it is confidential because under our Act, Section 16 of the Act, says that anything that's obtained under Section 13, which is how we get our information by compelling or having an interview, is protected by confidentiality.
Great. Anything else on that one?
No.
Just if we can back up, I mean, there are a couple of things Jennifer said that I think are important maybe to focus on for a minute. You referred to the fact that in Home Capital, the issue was brought to the OSC as a result of an internal whistleblower.
Right.
So the significant thing for people to think about is that most public companies will have a whistleblower program or policy of some kind within the institution as part of their internal checks and balances. The challenge for a company is that when you actually get a complaint through that process and it works its way to the board, what does the board do? And in this case, obviously we know the board made a decision that it would go to the OSC. And I think it's worth thinking about what are the consequences if they chose not to go to the OSC. Because this highlights the risk and problem for a board. If the board has the receipt of a complaint from somebody who's anonymous, they don't know whether the person will make their own complaint to the OSC. They don't know if they'll go to a reporter. And if somebody makes a complaint to the board and says there's some action that should be taken, and the board chooses not to take action, and then that person goes to the OSC, and then the OSC, on its own initiative, approaches the issuer, the challenge for the issuer in managing that dialogue with the OSC is complicated. Whereas if the issuer takes initiative and goes to the OSC, there at least is an opportunity for them to manage that. And so that's the first thing to note in this, is that the whistleblower causes causes a problem. The problem exists before the whistleblower. It's that the whistleblower identifies the problem and forces the board to do something other than it had intended to do. Now when you deal with the OSC, I listened to Jennifer and it sounds like there's Darth Vader that suddenly decides it's showing up at your door, and it doesn't work like that. All of our corporate partners and lawyers have good relationships with people at the OSC and corporate finance. That's true of all the major firms in the city. The relationship is a more cooperative relationship than I think people likely think about. And so you have this next challenge. When you go to the OSC, I refer to it as starting a dialogue. It is a dialogue. Mm-hmm. The OSC now has questions, and it can start in finance, if finance starts the review for some reason, or if in this case it comes from a whistleblower. And enforcement may not be involved. But now the problem is, what disclosure are you making in an informal way or formal to the OSC about what has happened? And how do you deal with, from the issuer perspective, the desire to manage it as an issuer and the potential for conflicts between the issuer and individuals who you know could be the target of an investigation or enforcement if you can't solve the problem? And finally, the piece I'd get to is that when you successfully manage this relationship, a successful one is nothing happens. Challenging moment is when the OSC, if it's finance or if it's directly to enforcement, looks at the problem and says, we appreciate your efforts. We know you want some credit for cooperation, but we think that you should be subjected to some sanctions. And we want some monetary compensation from the issuer and from individuals. Or we think there should be director education. Well, that is a very difficult issue for management and an issuer, because management and a board will never want to concede that they have committed a wrong and won't want a record that they've agreed that they've accepted sanctioning, because it has an impact on their reputations going forward. And here what we can see, I can only see from the public disclosure, is that you had that dialogue, and then there's a day when the OSC says, we're not getting agreement on sanctions. And when you don't get agreement on sanctions, then you get the notice of enforcement. And the notice of enforcement is served on Home Capital on a Friday afternoon, and the board and management make disclosure of the notice of enforcement and the fact that the OSC has a preliminary conclusion that there's been a failure to make proper disclosure. And then on Monday, the plaintiff securities class action firm that had been investigating this in any event files its complaint. And now the issuer, having tried to manage the process, is caught with having to deal with a regulatory proceeding and a civil proceeding at the same time. So there's more to this process that's more, I would say, more fluid than people can possibly think about until they're in it.
Yeah.
And when they're in it, no one's ever happy.
Well, and I would agree with that. I mean, we don't want to be the Darth Vader. I hope I didn't mean to portray that. We encourage dialogue.
Come on, you enjoy.
No.
When you get to serve, I mean, that's it. When you get to serve a Section 11 notice, I mean, I love it. You say it's confidential, and you go to Section 16, and you say, and the proceeding's confidential, and none of the information can be used. Like, that's supposed to give people comfort. The summons, most of you have never, I would expect all of you have never, and probably, I hope, will never receive a Section 11 summons. But if you get a summons, it's chilling, because it directs you to understand that you can't tell anybody about the fact you've received the summons except your lawyer. So imagine you're the CFO or you're a controller, and you get this envelope, and it's a summons. And you want to tell your colleagues that you're having to go in and talk to the OSC. Well, absent an order from the OSC, you can't. And now you're going in and you don't know, you don't have documents, you don't know what all the issues are they want to cover with you, and you're now giving evidence under oath that's being transcribed.
But there's a
That's
reason.
not, I know there are reasons for that. But I just mean to say, when I hear you talk about it, just for a moment, like, I want everybody to understand, it's not like it's confidential and it's a tea party.
No. But let's back up. So as you said, often, and we encourage dialogue, right? So if you're dealing with corporate finance or if you're dealing with enforcement, we encourage that. And then, yes, the summons may come. But again, the purpose behind the confidentiality is you don't want people tailoring their evidence. You can ask for the Section 11 order so you can understand what we are investigating. And I mean, frankly, it shouldn't come as a surprise. So,
and that's what the OSC always says. The other thing I just want to say, I just want to point this out, in that dialogue, right, the friendly dialogue we're trying to work through, managing the process, finance will say, more often than not, and we're an enforcement person, well, if you don't want to give us that information now, maybe we just need to issue a summons and compel you to do it. And then you have this challenge as an issuer. Do you want to force that breakdown in the dialogue, which is going to lead to a disclosure event? If you force it, you've got to realize issuer's going to get counsel. Each member of the management team and the board that is going to be summoned is going to get counsel. And so what started as a process you're managing, you think is going in a positive direction, fragments. That pressure that the OSC has to potentially cause that fragmentation, can cause people to take a different view and make disclosure in a more open context outside of Section 11 summonses.
Right. But I don't think it should be seen as scary as it is. I think the dialogue doesn't break down just because we issue a summons. And in fact, sometimes people ask for summonses to protect themselves from class actions and civil suits. So, and also the investigation, we're all obviously tasked with carrying out investigations, but I'm pretty sure don't do it, or most of us don't do it in any biased way. So it may not lead to a statement of allegations. An investigation is there to ensure there were or were not any breaches of the security.
I understand that. I'm just focusing on the fact that it is a stressful experience for counsel.
Yes.
And it's stressful for the board and management team who are going through that process because they don't control the outcome. And the OSC has a great deal of leverage over people in managing that process. And while it's comforting to know that the under oath interview examination is confidential and can't be used in another civil proceeding, the fact is no one likes to be examined or cross-examined by a lawyer.
Should we give David the last word?
No one finds that funny.
Yeah,
What's that?
Who gets the last word here? I'm glad we seated them beside each other. This is,
You said you wanted some.
well, I'm going to jump ahead a little. We have some questions that now in hindsight look quite funny, but I'll read them and we'll let David and Jennifer react. Jennifer, what are the OSC's expectations in terms of an issuer's response when you begin an investigation? And what implications can it have as the regulatory process plays out?
Right. So we expect full, timely cooperation. So, I mean, it really does rest with the issuer, and I think the tone comes from the top. If you receive a summons, that you produce what is asked in the summons in a timely manner, that not only helps us, but it'll help you as well, so that we can do a timely investigation. Also, what are the implications? If you cooperate and are frank with us, it can have implications down the road. So we have a credit for cooperation policy, which has been in place for quite some time now. And so if the investigation does lead to a conclusion that there have been breaches of the Act, if a potential respondent has been cooperative with staff, then there are a number of things that we can do. So that includes narrowing the allegations in an enforcement proceeding, reducing sanctions, also a settlement that is narrow and tight. We can recommend terms and conditions without an enforcement proceeding, and in limited circumstances, we may not take any actions. So if you cooperate during an investigation, there can be very positive implications for you with either statement of allegations or sanctions. On the flip side, if there doesn't seem to be cooperation, people are dragging their heels, it takes longer to investigate, there's a number of things that we may do. I mean, if productions aren't forthcoming, we may have to call in the CFO, CEO, or COO, whoever, and have you explain why the productions aren't being produced. As David says, that's not something that you necessarily want. Then also, I mean, we do have a big stick, but we never want to wield that. I don't think it's ever been wielded against an issuer. That, you know, if someone just isn't cooperating under Section 13 of the Act, you can be held in contempt. So we have to go to Superior Court and get that order. Like I said, I don't think it's never been used against an issuer, and I don't think it will. But I mean, if you're not cooperating, I think what we do is we bring someone in and have you explain, so it's more time and effort.
And I think just my experience with that is that you have to explain this to clients who are faced with these situations. I think many management teams and boards sometimes have an instinct to fight, like as they would on a civil suit, and often we'll get David or others involved to say, no, this is different than civil litigation. There is a big stick that can be wielded here, and we have to just think about this and approach this a bit differently.
What are you going to say?
Nothing for now.
You agree with all that, David?
Bill was chilling. No. I guess the only other thing, as you said, it's just, again, I'm trying to get these messages out so people can think about them. It's that when you start a process of meeting with the OSC, if you've listened to Jennifer and you know where they're going to go, that is looking
or may go.
They will always go for asking for records. That's always going to happen right out of the start. I think one of the things that people don't always do or don't want to do as much as they should is undertake a process of collecting records internally and reviewing them and ensuring that the story that is going to be presented to the OSC before you get there is a cogent, clear story that is consistent with internal records. Because where you can get yourself into a great deal of difficulty is somebody goes on behalf of the issuer and management, presents an answer to a question that makes something seem innocuous, and the OSC team will say, well, that's fine, we'd like to see some records, and then there's something inconsistent between the message that's given and the record.
Is that emails, everything?
I would suggest that people need to look at the minutes of board and committees that are relevant, and they most definitely should be looking at the internal records and emails that people have.
Because we do that full request, right? We will ask for a particular time period for all records, so that includes, yes, all emails, presentations, board minutes.
And you can get into this murky area where the last questions that get at the management team saying, well, we had legal advice, or we had accounting advice, and then you're into, well, are we declaring privilege or not declaring privilege?
So that
and that gets to be, those are difficult issues, but important to address from my perspective before you show up at the OSC as opposed to afterward.
Maybe, David, it'd be interesting to hear how the civil litigation process kind of overlays this, and what are plaintiffs, the plaintiffs bar looking for, in these types of situations, and how does that kind of overlay on top of a potential OSC enforcement proceeding?
All right. Well, I think that if we think about plaintiff class actions, a number of people are, have certainly heard of them. If we back up to 15 years ago, we didn't have many, and we certainly didn't have any before 2005, because the regime is only introduced in 2005. Over the next 3 or 4 year period, there were not many class actions that were commenced, and there was a period of a large number of them, and then we've had a number of key cases that have highlighted the challenges for a plaintiff in making sure those cases move forward successfully from the plaintiff side. And as a result, there has been less of a keenness for people in the plaintiff's bar to look at, I'm going to say, less obvious cases and think that they're going to commence an action because they're concerned that they can invest time and money and lose and have an unsuccessful outcome. What they look for is first, and this is not rocket science, it's you look for a significant change in a company's market capitalization tied to or shortly following the release of adverse news. And then you back up, as I said, and you review the company's disclosure. And that means putting together news releases, the MD&A, financial statements, transcripts of earnings calls, and analyst reports. And you study that, and you can go to blogs and look at what people are saying on different blogs that have people following the company. And you ask that question, do you think the company knew this information earlier and should have made disclosure of it? And so that, like in Home Capital, the plaintiff's firm started to study this after the company's first disclosure and the initial decline in the share price. They didn't commence an action. They'd identified a shareholder to be a plaintiff, and they were ambivalent about whether they would pick this as a case to pursue They think in retrospect, if the OSC had done nothing, they would have proceeded. But the real turning point for them was on the Friday that the company receives the enforcement notice, and then it makes that disclosure of the enforcement notice and the OSC's preliminary conclusion. And on Monday morning, the firm that had investigated files its claim, and now you have a civil claim and you have the regulatory proceeding, and they're difficult to manage in tandem because you want to settle the OSC proceeding, but you can't settle an OSC proceeding without reaching agreement on sanctions and a statement of fact that responds to a statement of allegations. And then the plaintiff lawyer will look at that settlement and will try to rely on that as a basis for helping ground their civil case. On the other hand, the OSC doesn't want to settle too early either, and you've got the civil claim that's proceeding. So you have almost two stakeholders now trying to seek a remedy. And with the company, you have an insurance policy. If you have an ongoing company, it's easier because the company has earnings, but if you have a Sinoforest problem, you just have the insurance policy. And so the plaintiff lawyer looks at it and says, we're losing funds every day off the insurance policy, the longer both proceedings carry on, and they have a challenge. What was unique about this case, which would be interesting to hear more from Jennifer about to the extent she can talk about it, is this was, as far as I know, the first time that the OSC settled a proceeding that it had commenced in tandem or in parallel with a civil claim, and where, as part of that settlement with the OSC, the bulk of like $11 million of $11.5 million that was agreed to be paid was to be directed toward the class proceeding settlement of $33.5 million, and so it was going to be available to shareholders. And both proceedings settle coincidentally and conditional on each other, which is a unique outcome.
So yes, it was unique. It was the first time that, as David said, we had settled at the same time as the class action, and we made the two settlements conditional upon each other. Ours went first, but it wasn't in full effect and force until the court also approved the settlement. And so that was one unique thing, that we did it together. It is public. There was a mediation that took place that involved all the stakeholders. That was done by Chief Justice Winkler. So that was unique. And the second unique thing about it was the payment pursuant to the OSC settlement that went over to the class action. And one of the things that we insisted was that the $11 million that went to the class action was 100% flow through to investors, that neither the class action plaintiff lawyer fees or the administrator fees could come out of that 11.5. And it was a total of $28.5 million that is available for the class and the class action, and that distribution is ongoing. I just wanted to add one other point too, with respect to what David had said about the difficulty in settling, because if you settle with us, there may be omissions, and that can have an impact on a civil case. We do have no contest settlements as well. That did not happen in Home Capital, but there have been a number that have happened at the OSC, in particular with a number of banks and financial institutions. So there is a possibility, it's set out in the policy, the same credit for cooperation policy, where a company can enter into a settlement with the OSC on a no emissions basis, and that would have implications on the civil side.
And so if there was no class action lawsuit and it was just an enforcement settlement, where would the funds have gone? Investor Protection Fund or something? So,
yes. So we have the ability under the Act, it's under Section 3.4, Sub 2, Sub B, I know this too well, where funds can be designated pursuant to a settlement to be paid to a third party. So there are circumstances where we can pay money to investors. have to keep in mind that the Commission is not a restitutionary body. We do not have the power to, or the Commission does not have power to order restitution, so different than a court. But if money is paid to us, there is the possibility to pay to third parties, which can include investors. It can go towards education. I mean, Home Capital was a unique case where there was the class action, and so it made sense that the money could flow over there because you already had a distribution process in place. But there are ways at the OSC that we can distribute money as well.
Thanks. So the other topic I wanted to touch on today is the whistleblower regime, because I think it played a pretty interesting role in this case. It's an example of, it's, I think, exactly what the policy was intended to do. So maybe we could turn to Brad for a minute to give us a bit of an overview of how the system works and what's involved.
Sure. The whistleblower program came in recently, last year, I believe, and it's with the intent of encouraging individuals to report breaches of Ontario securities laws to the OSC. Very simple. It provides financial incentives to whistleblowers who voluntarily provide the OSC with meaningful, high-quality information that can help in the investigation of a matter and obtaining a decision that results in a financial payment of some types. Whistleblower complaints can now be lodged anonymously. There are protections in place for those who come forward, including confidentiality and non-anti-retaliation measures within the program. And finally, the most important part is that eligible whistleblowers are entitled to receive financial rewards for some of the information they provide. These awards can range from 5 to 15% of the sanctions up to a maximum of $5 million. Interesting, you contrast this with the SEC whistleblower policy, which I think generally awards up to 10 to 30%, and we've seen huge awards in the tens of millions of dollars. So the OSC made a decision. The
classic Canadian compromise.
Correct. Yeah.
Thanks, Brad. Okay, so Jennifer, can you tell us a bit about what, I think just generically, I mean, if you can speak to Home Capital, that's great, but generically sort of how is the program working at the OSC? Are you seeing more complaints? What's the experience been in terms of the level of complaints? And I guess interesting to know if you're finding some of the claims are false or if there's, any kind of issues around that.
Sure. So as Brad said, it hasn't been in place for that long, just over a year. It is staffed by a team of professionals, so accountants and lawyers, and it is separate from enforcement. So I'm not part of the Office of the Whistleblower, but it is part of enforcement. So to date, the office and the OSC is pleased with the program. There have been hundreds of tips that have come in, and several of those have led to active investigations. So to date, there have been no cases that we have launched yet that are based on a whistleblower complaint, and as a result, no awards. But I can tell you that there are several active investigations. With respect to, has there been an uptake? I mean, I think the numbers are probably in the range of what they thought they would get. And because it is staffed by professionals, they triage the claims or the information that comes in. I don't have any direct information from them, but they will take a look at it, and if it's something that seems outrageous and egregious, I think obviously that's not going to lead to an investigation.
Did you say, so are you able to disclose if there have been awards under the program?
None yet. We have not launched any proceedings yet based on a whistleblower complaint. So
Home Capital doesn't fall into the...
No, so the Home Capital was based on an internal whistleblower that they brought to us. Our program wasn't yet in place. So because the whistleblower complaint in Home Capital was dated June 1st, 2015, right. And they came in shortly after that.
I see.
So, so it wasn't through our Office of the Whistleblower.
Thank you. David?
Got a question.
So in all this back and forth, when there's an investigation or there could be an issue on disclosure and the OSC is looking into it, at what point do shareholders sort of come into the loop, and is that disclosed that there could be an issue? And what happens also in the case of a whistleblower or in the case of an investigation if it gets leaked or the press comes out with a story? How does that get handled?
Yes. So, so as I said, our investigations are confidential, so investors don't know what we're doing. I mean, the investigation may be as a result of either a complaint from an investor at the contact center or as a result of a whistleblower letter, but they are not part of our investigation. It's protected by Section 16 of the Act, so if there is a leak, we can take a look at that because that is a breach of the Act. So we can actually bring proceeding against someone if we know that they have breached the Act, and you'll sometimes see that in not disclosure cases. But I have a case right now where we're alleging that the respondent breached Section 16 by telling others about the investigation, and he can be sanctioned for that.
And my understanding is the whistleblower regime is confidential. So, if a whistleblower complaint comes into the OSC, there's no public record of it. You can't do a freedom of information request and get that information.
Exactly.
I just think that one of the things to think about is that the actions that are taken by the OSC or by a plaintiff securities class action lawyer are generally all predicated off of a company's disclosure. So that when you ask the question, when do shareholders come into the loop, from my perspective, they all are, to the extent that they're following the company's disclosure. In terms of when do shareholders learn of an OSC investigation, Home Capital is an example. When the OSC reaches a conclusion that it's going to commence proceedings and issues a notice of enforcement, an issuer will, in all likelihood, make disclosure, as Home Capital did, of that fact. And then what do you know? Then you know that somebody has looked at the prior disclosure and has a concern with it and is saying that they think there was a failure to make disclosure in accordance with the Act.
And if I could just make clear, our enforcement notices aren't public either. Like, we don't post those anywhere. It's the company that chose here to disclose it because they felt that they were obligated to do so.
Oh, I see. Interesting.
Yeah. So in most cases, no one knows that the enforcement notice has been issued.
And the challenge for an issuer would be, you might say, well, the fact that there's an enforcement proceeding doesn't constitute a material change. But what their concern is, they're confronted with somebody who's questioning their earlier disclosure, and if they don't make disclosure, what happens if the proceedings reach a point where they are going to be public and you've not disclosed the fact of the enforcement proceeding? And now I have shareholders who are saying this is part of a course of conduct where a board and management team have been trying to shelter themselves from transparency to the market and have withheld material facts or made misstatements or have failed to disclose a material change in a timely way. So disclosure of that kind of an event, though unpleasant, probably isn't, I would say, is important in terms of protecting people from subsequent criticism, because it is a significant event.
Thanks. So we're now, I think it's 9:27. Maybe we'll open the floor up if there's any other questions before we sign off today. If not, well, thank you everyone for joining us. Oh, one at the back.
I'm just wondering, I can't remember the section of the Act that permits the disclosure of the confidential nature of the investigation to people other than counsel, for example, maybe the insurers, who find it very relevant to know what's going on. Can you talk about how the process and how quickly that order, I don't know if it's 14 or 17, can be obtained?
17. Yeah.
Thanks.
So it's a Section 17 order. It has to be issued by the Commission. And as you said, we often get requests for that for insurance purposes, that the D&O have D&O liability policies. It can be done in writing. You can send a memo to the Commission and ask for the order, so it can be done pretty quickly.
All right, well, thank you everyone for joining us today. Thank you to our panelists. Jennifer, thank you for coming. Very interesting. Just one note before we sign off. Our next Goodmans Presents is on October 25th, and our partner, Jacqueline Seidman, will have Kelly Hoey here, and it looks like a really interesting session. They're talking about building networks, networking, building relationships, those kinds of things. A little different than this type of session, but looks to be pretty interesting. So great to see you out if you can make it. Thanks, everyone.
Thank you, Jennifer. That was terrific.